I'm going along, please feel free to communicate that via the chat. And with that, let me hit this button. Okay, cool. So my name is Chris Berry, and we do these workshops or webinars about once a week, every Wednesday at 1 o'clock. And they're also recorded to our YouTube channel. So you can watch previous episodes if you want to, or if something's unclear, or if we cover something and you want to forward it to a friend, you can do that all via our YouTube channel. Just search for Castle Wealth Group YouTube and it probably shows up. And so we do these every week at 1 o'clock, and it's really an opportunity just to answer questions or talk about kind of what's going on in the news or changes in law or markets and that type of thing. So let me share my screen real quick. And hold on. And I always start with a positive focus, something positive that happened. And my positive focus is that just hung out with my son yesterday. So I have a son and daughter, and I don't get a ton of like one-on-one time with them. And we had a nice Daddy Sunday. We went to a bookstore. He picked out a book on American history for teens. He's really into history, so it's kind of cool. And then we played around on the lake, so it was nice. All right, and this is all general information. If you have questions, feel free to book some time on my calendar by going to 15chris.com. And with that, we will jump right into it. So the first question I have submitted is, I've saved mostly inside my company's 401k as I approach retirement within the next year. So retirement next year, I want to roll that money into a Roth. What do I have to do? So there's a little bit more to this, but what makes a Roth kind of special is it's post-tax, and the growth on it is tax-free. And so everyone kind of defaults to, I want Roth money if you think taxes are going up. But here's the thing. So a 401k, it's pre-tax. And also it's what we call an employer sponsored plan, meaning you don't have full control over that 401k. Like if you have a 401k right now, you're limited in terms of what investment choices you can make inside of that 401k. Basically, your employer kind of contracts with other like Fidelity's or Empower or someone else to put together this plan. And then that plan administrator gets to pick and choose what investment choices you have available. So with a 401k, you're typically limited to, in terms of investment choices, in terms of how those portfolios are put together, but also you're limited in terms of what you can do with your money even. So that's why what most people do when they retire, or even before, if their company allows for in-service transfers, is they roll that money over to an IRA, which it stands for individual retirement account. So 401k, think of it as kind of limited. An IRA, you have, it's your own, and I almost call it like an independent retirement account, meaning you can really do whatever you want inside of the IRA. You're not limited to this just base selection of investment choices or portfolios. You can do stocks, bonds. You can even do real estate inside of an IRA. You can do annuities inside of an IRA. There's a lot of different options with IRA. So not only do you have freedom in terms of your investment choices, but also you have a lot more freedom in what you do with that account. The IRA is still pre-tax. Okay, so we haven't gotten it into the Roth at this point, but really now you have a lot more freedom to do whatever you want to do with the investments and invest however you want. Now, the purpose of this question was to get over to the Roth, right? So what has to happen is, okay, now that we've rolled it over from the 401k to the IRA, there's no taxable consequence on that. Now we need to start thinking about, and we would look at doing this in an intelligent manner, start doing what we call Roth conversions. And I'm not saying that the Roth conversions or Roth IRAs are the only way to go. It is a simple way to get money to that tax-free bucket. And remember, if we're talking about what kind of grows tax-free, we have things like Roth, cash value life insurance, index universal life, 529s, which have to be used for health or education, and health savings accounts. All of these grow tax-free, so you don't owe any capital gains on it. And really, whenever we're doing this, we're looking at how much to convert, because you do have to pay tax. So how much do we pull out of those pre-tax accounts? And then where do we put it? So we don't always put it into the Roth, but that's the way kind of everyone defaults when they initially start thinking about this. But again, so we roll the money from the 401k. We can either do that now or when you retire, assuming they allow for in-service transfer. Now it's an IRA. We can do what we want. We can do the Roth conversion, and we just need to make sure that we pay the tax as we pull money out of the IRA, which we call the always tax bucket, and put it somewhere else like a Roth. So it's more than just 401k to Roth. We have to do 401k to IRA, and then IRA, then we can start talking about Roth conversions. So hopefully that was helpful. What is the maximum I can put into a 401k, and what about catch-up contributions? What if I contribute more, or does it automatically shut off the contributions when I reach the max? No, it's not going to. So the person has a 401k, so they're still working. How much can they contribute? It's based on their age, and I always reference my key data for 2021 sheet. And if you email me, I can send you a copy of it. But the 401k, the maximum contribution is $19,500. And for people over the age of 50, you have an additional catch-up provision of $6,500. So if you do have a 401k, the maximum contribution is $19,500. And then if you're over the age of 50, you can contribute another $6,500 to that 401k. Now, what I would recommend, depending on where you're at in terms of tax brackets, is looking at if they offer a Roth 401k option. So you have your traditional 401k that is pre-tax. See if your company offers a Roth 401k, because otherwise I might not be overfunding that traditional 401k anymore, because taxes are scheduled to go up in the future. Plus, being $30 trillion in debt, I think taxes have to go up much higher in the future. So a lot of times people just default to putting as much into that traditional 401k as possible. I'm not saying don't save, but I'm saying maybe we should rethink where we're saving that money. For example, I'll just share in my own personal situation. I stopped all contributions to pre-tax accounts this last year, and I'm saving in post-tax accounts or tax-free accounts, at least for the time being, given that the Tax Cuts and Jobs Act says that taxes are going up in the future. So yeah, so that is a lot on 401ks. Which was I said a couple of questions came in here. I'll get to those. So thank you for those additional questions coming in. We'll get to number 2 here. My mom fell and is in a nursing home recovering. And so it sounds like she's probably covered by Medicare. Someone said I should get a guardianship because of dementia. Is that the right next step? I probably would lean towards no. So the problem with guardianship is it's basically living probate. So you're going to the probate court to get control over someone, and that's called a guardianship. And if they happen to have money, like over $100,000, then you might also get a conservatorship. So this is really relying on the government's rule book versus creating your own rule book. And now you're leaving up to the courts to decide, A, whether your mom actually needs a guardian. And that is a tough step, because a guardianship, you're taking away someone's independence. I call it a nuclear option. It's like the last thing we ever want to try. So A, the courts would make a decision of whether she needs a guardian or not, and she might not, and they're going to appoint a court-appointed attorney to advocate on her behalf that she's okay. It's basically taking your mom or your loved one to court. And then second, they would appoint a guardian, which could be you or could be someone else. Could be a court-appointed lawyer that has 250 other wards of the state that they're quote unquote taking care of. So I wouldn't go the guardianship route right away. Instead, what I would do is make sure that we create that your own rule book with an estate plan, and more specifically, what we call disability documents. The big things being your financial power of attorney. So that's a document to make financial decisions for a loved one. And then the other one is the medical power of attorney to make medical decisions. So the medical power of attorney is kind of like the alternative to guardianship. Financial power of attorney is the alternative to conservatorship. So as long as your mom's having lucid moments where, yeah, they might have a diagnosis of dementia, but as long as they understand what they're doing, even if they may forget it or something, then she probably still has capacity to do the financial and medical power of attorney, because then that'll give you the authority to make decisions for mom without having to go to court and getting the courts involved. So I'd try not to do the guardianship first. I would start here before going the guardianship route. All right. All right. What is the best use? So this question just came in. I was able to type it up right before we hopped on. What is the best use of the federal estate tax exemption if we're married and have a net worth of 8 million? How do you make a claim or report either exemption when one spouse passes? Yeah. So we're talking about estate taxes here. And right now, the estate tax exemption, think of it kind of like a coupon. Right now, for a single individual is $11 million. For a married couple, we can double it. And with the inflation, it's basically $23 million. Meaning as long as you're married right now with less than $23 million, you owe zero in estate taxes. But that is from now, or actually 2018 till 2025. And that's when the Tax Cuts and Jobs Act expires. And now it drops down to 5 million adjusted for inflation. And for a married couple, it's $11 million. So if we're sitting here at 8 million, two things. Three things. One, you're currently under, and you will remain under the estate tax exemption as it currently sits. Now that said, the second thing is your estate may continue to grow. And the third thing is the estate tax exemption may continue to drop. So President Biden's proposal, so this isn't in effect yet, it's just a proposal. But the proposal, as President Biden's proposal, is to drop this down to 3.5 million for a single individual, which would take this to roughly 7 million for a married couple. So now if you're sitting at 8 million, if President Biden's proposal goes through, now you're going to have excess of $1 million over the estate tax estate tax exemption that's going to get taxed at 40%. And then here's the thing, if that money is pre-tax IRA money, you're going to have two taxes that you have to worry about. One is the estate tax, and then the second is the income tax. Because if they're inheriting pre-tax dollars, then they have to pay tax on that. And also, if President Biden's proposal goes through and you have taxable accounts, then you lose step up in basis. And so now your kids will also have to worry about your capital gains on anything they inherit as well. So in essence, there could be three taxes upon death if you're sitting at $8 million and President Biden's proposal goes through. You have an estate tax, which is going to be 40%, so $400,000 on that $1 million. Potential income tax if it's IRA money they're inheriting. And then if it's like taxable accounts, real estate, they might have to pay capital gains if they were to sell. And this is another reason why I say taxes are one of the biggest risks and biggest opportunities right now. If whoever you're talking to or is helping you isn't talking to about taxes, whether it's income tax or state tax or capital gains, they're really missing the boat in terms of advice. So there are some things to do given this lower dropping of the estate tax exemption, because kind of what's happening is I see this with a lot of my clients, especially with the markets. the value of their estate is going up, but the estate tax exemption is going down. So if we're right here and there's like today, 2020, this could easily be 2025, where now we're going to have an estate tax issue. So one of the things that we could do is, okay, if we're at 7 million now, maybe we can move $1 million into something that's is removed from your estate now before this exemption continues to drop. And there's some different strategies to do that. So that'd be more a proactive planning. So if you do have an estate worth about 8 million right now, I'd say let's have a conversation and talk about whether we want to take some proactive steps before this Tax Cuts and Jobs Act expires or before President Biden's proposal goes through. Because with the larger estate tax exemption now, there's some things that we can do to take advantage of it before it drops. And then the second piece of the question is, how do you make a claim or report the exemption when one spouse passes? Well, that's what we call portability. And we've had portability ever since 2011. And portability means when one spouse passes away, that coupon or exemption isn't completely lost. All you have to do is make a tax election. So it's just a tax form that's filed when one spouse passes away to lock in that exemption. Prior to that, we would always have to do separate trusts for a married couple, one for one spouse, one for the other, to lock in those exemptions. It was kind of silly. But yeah, we would do what we call AB trusts. So prior to 2011, we would almost always do AB trusts, separate trusts for spouses. But then 2011, they passed a change in law, and now we have portability. Now we have portability, where all we have to do is just fill out a tax form when one spouse passes away to lock in that exemption. But again, that's just going to double the exemption. And if we're sitting at 8 million and it's potentially going to drop to 7 million for a married couple, there might be some proactive planning that needs to be done. All right. A couple more questions that came in here. Whoops, I just answered that one. State claim or exemption. All right. Here's the last question I have submitted. So if you do have any more questions, please put it into the chat or the Q&A. So the question is, all right, we have a retirement benefits trust. Holds all your tax deferred accounts, requires that your kids only take out the funds evenly over 10 years with the balance in the 10th year. Okay, I'm sorry. I'm reading this on the fly. Can your retirement benefit trust, okay, all right. So the question is we have these pre-tax accounts, okay? Accounts that you haven't paid any tax on. We also call this tax deferred. And these are things like your traditional 401k, IRAs, 403bs, right? And all this money is pre-tax. You haven't paid any tax on it. So if you're sitting there and in the account you see that you have $1 million, you don't really have $1 million because why? You still have to pay your tax liability at some point, either while you're alive or now when you pass away, the kids have to pay the tax on your death within 10 years. And so in 2020, which seems like a lifetime ago, we had the Secure Act. And prior to the Secure Act, the kids, if they inherited this, they could pay the tax over their lifetime. Okay. So if they inherited $1 million, and let's just say there was a tax liability of 25%, so 250,000. Whoops. I wish it was only that much tax. They would have to pay they could stretch it out over their lifetime. Well, when the Secure Act passed, nope, not over your lifetime anymore. Now all the taxes have to be within 10 years. So now with the IRA, there's two ways to leave the account to the next generation. One is through a beneficiary designation. Okay. So you could just name your kids outright and then they inherit the money. But what happens if there's a divorce, a lawsuit, creditor action, bankruptcy? They might lose that money. Or what happens if you don't trust them financially? So instead, what a lot of people do, and most of our clients, they'll leave it to a trust. And these days, you don't have to do a separate trust. This could all be done in one trust. In the past, we used to do a separate trust for the retirement accounts. Now we do it all in one trust. So we have your qualified and non-qualified in real estate all going to kind of one trust. And that trust could build in this language. So what the question was getting at is, okay, so with the Secure Act, what it says is all the taxes have to be paid within 10 years. But what it doesn't say is how do we want to handle the taxes? So we could pay all the taxes right up front, okay, but that would drive up your tax bracket. We could pay all the taxes in the 10th year. So it could grow for another 10 years tax deferred before you pay taxes. Or you could take it out and pay the tax evenly over the 10 years. And so if you leave it outright to a child, they can decide how they take it out. But with a trust, to answer the question, yeah, if we wanted to set up a trust, we could say specifically in the trust that this is how the retirement accounts would be handled, is that we would pay the tax evenly over the 10 years. Or, and then the balance in year 10 if we wanted to. So yeah, that's where a trust is creating your own rule book. And so we can create the rules of how we would want to handle those retirement accounts. All right. So that is all I have for questions. Any more questions? Please submit them real quick. Otherwise, going once, going twice. Sold. All right. Well, take care, everyone. Thank you so much. Make it a great week. Bye-bye. Bye-bye. Bye-bye.